Today on Categorical Imperatives, we are going to be talking all about legal standing, what it is, what it isn't, how it applies to citizens and government, and what its role has been and is in the recent Trump Texas election suit. Hey, greetings and welcome back once again to Categorical Imperatives. As always, I am your host, Lockie and Liberal, and I do want to thank you all so much for being here with me today. If you are new to this program, I want to welcome you. This is a podcast where we are going to be using legal theory and moral philosophy to discuss current events related to law, politics, and culture. And today we got something a little different for you guys. For anyone who watches the show with any regularity, this is going to be very different than what I usually do. Usually, I like to come to you guys with a very polished and clean and worked up script. I write them out and I go over them and I rework them. And I try and get everything as perfect as I can and give you a nice, polished, finished product. That is simply not going to work for today. Because today we are going to be talking about legal standing, but I'm not going to be doing it in my normal way where I just have like a set presentation for you guys and I read from a script and everything sounds perfect and everything I say is exactly right and it just sounds exactly right. And it's going to be a little sloppier than that. And this is going to be because this is actually in response to the last video I did where I did a video more like that talking about the Texas election suit, the Texas versus Pennsylvania case. And I'm going to kind of be replying to a lot of sort of comments that I got about that. And one of them is going to be actually, I have a regular viewer, a guy over on YouTube, screen name is Jay David, and he asked me a really, really good question about standing, and it was so good that I decided I wanted to make a show about his question and my answer. But the thing is also over on BitChute, where people are a little more, I don't know, but I put the same video up and I got a very different reaction from people. I got a lot of really angry Trump supporters who were getting very upset at me. Now, I don't want to be overly critical. There were a couple people who were Trump supporters and who thought I was wrong and who said so, but said so in a very, nice and polite and friendly way. And I responded and they replied back and we had a good back and forth. And we parted ways with them still not agreeing with me. But I mean, we had, a decent conversation. I have no problem with that. I have no problem with someone who, talks with me and we have a good discussion and they just say, well, I still disagree with you. I mean, I am right, but I can respect that. So that this isn't going to so much be referring to that. There were really kind of two other classes of comments that I got that I am going to really be more addressing. And the first one was from people whose reaction was essentially, there's no such thing as legal standing. It doesn't exist. You don't know what you're talking about. Legal standing isn't a real thing. It's not in the Constitution. And if that wasn't bad enough, there was another class of people who were a little more frustrating still, whose response was essentially, they saw the thumbnail that I made for the video, and their response was, oh, so you're a constitutional lawyer. Well, that's why you don't understand the Constitution. And those, yeah. Oh, man. And that, like, I hate people. I don't like arguments from authority, and that's why I don't come to you guys like, this is my professional opinion as a constitutional lawyer, because that shouldn't really matter, I mean, facts are facts, right is right, and wrong is wrong. But, at the same time, I mean, people, yeah, I don't know, people who say, oh, well, you've taken great pains to understand this thing, because you're very passionate about the Constitution and you think it's a great document, and you have decided to go into a field where you can spend your life defending this thing that you care so deeply about and that you want to understand as much as you can, so you can defend it as effectively as possible. You must not know what you're talking about. And to those people, really all I can say is fuck you. So sorry. Yeah, like I said, this really isn't going to be like most shows. I'm not going to be this worked up the whole time, but this is really going to be more of an off the cuff show. So basically what I'm going to do, first of all, I'm going to go over the question that I got from that YouTube user. I basically typed up the question he asked me and the answer I gave him, because I think it was a really good question. And to be quite honest, I think it was a really good answer I gave. So we're just going to read that. And then for all the people who said there is no such thing as legal standing under the Constitution, and I'm not talking about these kind of people. They are idiots and they don't deserve to be to get a reply. But for the people who were angry at me because they support Trump and they're very passionate about Trump and they wanted to see him get reelected, and they think that he won the election, and they are just looking for any reason to believe that he won the election. I'm a little more sympathetic to that. So that's what I'm going to more be responding to here. And so what I'm going to be doing is, in the last video, I went through a part of a lawsuit that was filed as an Amicus Brief. And what I did is I essentially read the beginning of it, which was the file for motion for leave, which kind of just introduces you to the case that they were going to be making. And so what we're going to be doing today is actually going through the amici, the brief itself, and I'm going to be going through that, and I'm going to be kind of putting on my constitutional lawyer hat today, and I'm going to be going through and giving you a really in the weeds legal analysis of what it is and why it explains what standing is, and why standing is a real thing, and why Texas did not have it in this case. And I'm just going to be making as solid a case for that as I can. So that's what we're going to be doing today. So let's get to that first part, the question. So this was the question that I got from that user, Jay. So thank you for that question, by the way, Jay. I assume you're probably going to be watching this. It was a great question. I really appreciate you asking it. And so, yeah, what he said was, I noticed that you mentioned standing. Could you explain that and how it relates to citizens and government? And to which my response was, I think the best definition of standing comes from the Supreme Court dicta in the case of Worth v. Selden, which was a case from, I think, 1975. And what the court said about it was, in essence, the question of standing is whether the litigant is entitled to have the court decide the merits of the dispute or of particular issues. And I went on to say that Legal standing plays some roles in certain aspects of state courts, but it's much more prevalent in federal courts because the federal courts are meant to be appellate courts. There are a number of requirements that a plaintiff must establish to have standing before a federal court. Some are based on the case or controversy requirement of the judicial power of the Constitution under Article 3, Section 2, Clause 1. As stated there, the judicial power shall extend to all cases and controversies. And the requirement that a plaintiff has standing to sue it's not a limit on the citizen. And that's one thing that's really been bugging me, that people have been saying, the people who are upset about this case, is they're saying, well, we're citizens of the United States. Where do we have standing? Which is a ridiculous question for a lot of reasons. Again, I get that it's a question being asked out of sort of passion and frustration over, politics that you care deeply about. And I get that, and I really am sympathetic to that. I don't mean to be too mean here, but essentially, that's a ridiculous question because, first of all, this case wasn't a case brought by a citizen. It was a case brought by a state. Now, a state and a citizen, with very few exceptions, are not the same thing at all. They're not the same thing in life. They're not the same thing legally. They're not the same thing before the court. So, and second of all, there are places where both citizens and states have standing over these issues. And that's one reason I almost don't want to address this issue, is because the libertarian in me sees conservatives losing faith in the Supreme Court and realizing that is actually in some ways a very good thing. Is that conservatives have become just as big a big government supporter as liberals are. They just don't realize it. When they think that the only place that anyone can get any resolution to any question or any issue or any concern is from the federal government, and if Congress won't pass a law, and if the Supreme Court won't give a judgment, then the people are just completely fucked, and that must mean that we have no representation, and there is no one looking out for us, and that is simply not true. That is simply not true. And that's the thing, is we were not, the people, the citizens, the individual citizens were not meant to deal directly with the federal government. Because the federal government is a government of limited jurisdiction. The states are where general jurisdiction lies. And that is where the people have standing. We are represented by the states, and the states are represented in the federal government. And so that, yeah, so I really, there's part of me that like seeing conservatives lose faith in the federal government, because they should lose faith in the federal government, because that's not where they are supposed to look for a resolution of their issues at all. Even especially in elections, and even federal elections. And that they get this on some level. They get that the Electoral College is a good thing, because what we have is we don't have one big national popular vote, because we're not one nation. We are 50 federal sovereign republics, and they get that, and they get that it is a good thing in that sense. But then, when an election doesn't go their way, they get that they get that it's good to have a federal election, but then they think that it's a bad thing to have a federal resolution of election issues. They think it should go to the national government. Why are you looking to the national government to limit its own power? Why do you think that that's going to end good for you? It's not. It's never going to end good for you. Why would you ever look to the federal government to limit the federal government's power? Sorry, I'm getting much more worked up than I wanted to, but this is something that has been building up for me for a long time. It's just that, it's frustrating that conservatives see themselves as the defenders of the Constitution. And the thing is that the only difference is that liberals don't even pretend to look to the Constitution. They just kind of look to whatever they want to appeal to. They just want to look to big government because that's the solution to everything for them. And conservatives say they believe in the Constitution, but then they look to the federal government for everything, even things where the Constitution says the federal government has no authority and no jurisdiction. So I'm very conflicted here because I'm going to be explaining why the Supreme Court was right and why conservatives who are pissed off about this shouldn't be upset at the Supreme Court as though the Supreme Court did something wrong, because they didn't. What happened here is the Supreme Court, in a very, very rare instance, recognized that it is a court of limited jurisdiction and ruled that way because that's what the Constitution demands. And conservatives, the defenders of the Constitution, are mad at them about this. It's just... So anyway, sorry. I really kind of got off course here. All right, let's get back to Jay's question and the answer here. Where were we? So, the requirement that a plaintiff have standing to sue is a limit on the role of the judiciary, and the law of Article 3 standing is built on the idea of separation of powers. Federal courts may exercise power only in the last resort and only as a necessity. And this is why, for example, when the Supreme Court adjudicated the case of Bush v. Gore in 2000, what people don't get is that was completely in line with the Constitution, because Al Gore filed suit in the Florida court who have original jurisdiction over election disputes. And in fact, the Florida court technically has appellate jurisdiction too, which is why he sued in state court. It then went to the Florida Supreme Court for appellate jurisdiction, but what happened was, because the case could not be resolved by the statutorily defined time limit to settle disputes, Bush then appealed the case to the federal courts, who, because there was an unresolved dispute under the state law, then had appellate jurisdiction, and thus gave George Bush legal standing to bring the case. So, under original jurisdiction, there would have to be 3 procedural elements to prove to have standing. And they are injury in fact, causation, and redressability. Now, injury in fact requires a concrete and particularized harm that is actual or imminent, not hypothetical or conjectural. So, for example, with the Texas case before the court, what they said is, there is, we see these things that make us think that, there was possibly election fraud, and we don't have proof of the election fraud, but we have a feeling that there was election fraud. And so we want you guys to take over this case because we need to find out if there was election fraud, because if there was election fraud, and if that election fraud was enough to swing the election over to a candidate who didn't actually win, then the citizens of Texas will have their votes diluted and they are thus meaningless and there is an injury. Now, that is just, absolutely hypothetical and conjectural, We think there was a problem, and if there was a problem, then we need to know. And then if there was a problem, we need to know if it was a big enough problem to change the election, because if it changed the election, then maybe it possibly had a negative effect on the citizens of Texas. That is not an actual or imminent injury. That is conjectural and hypothetical, just completely. So that's injury in fact. Then causation. You need to demonstrate that the injury was a direct result of a law passed or an action taken by the defendants. Now, if you haven't proven the injury, you can't prove causation. It's just that simple. And then, if the court, if you do prove causation, you then have to prove redressability, which means that you have to prove that if the court did rule in your favor, that the judgment that you are seeking would redress the injury. And again, this is a, this is a step-by-step process. To have redressability, you first need to prove causation, because if you can't prove that the defendant caused the harm that you are saying, then you have no way of proving that the harm that was caused is redressable. And if you haven't proven the injury, you can't prove the causation. So this is the reason that Texas's case was thrown out immediately before the merits were considered, because before the merits are considered, you have to have standing. This is the legal requirement for standing under original jurisdiction, and Texas did not meet any of these three requirements. Not one. Okay, so with that out of the way, let's get to sort of the other thing that we're going to talk about today here. All right, so this is the brief that I had read from. I had quoted the motion for leave, which is the first part here. You guys will recognize this. I'm not going to read through this because I did this in the last video and because all of this is repeated in the actual amicus brief itself. But this is what I read for you. Here is this stuff that I'm scrolling by, which was the motion for leave. So now we get to the actual amicus brief, and I will be having a link to this brief down in this video's description. So I really highly recommend, for anybody who's interested in this, go and read this brief for yourself. I mean, you may even want to pull it up and read it through with me as I'm reading it. That may help you. But even if you don't, even if you just kind of watch the video and listen, still, what you'll see is that they have a table of authorities here, and this is all the cases that are quoted in the amicus brief, and it gives you links to all of them. So you can go and you can further, and I'm going to be talking about the cases and pulling up the case law, and we're going to be going through them together as well. But it's a great place for you to go and kind of look into this more yourself. If this is the kind of thing you're interested in, you can go and look up these cases for yourself and read the full case brief on them, which I recommend you do. And then here, this also lists every constitutional and statutory authority that is cited in the case. And again, I'm going to be pulling up the case law as we get to them, and I'm going to be explaining these as we go along. I'm really going to be getting into the weeds on this one, so you guys will have an understanding of this stuff. But this too is, if you're interested in this stuff and you really want an understanding of this, you can go and look up this case brief and look up these laws and I'm not going to be reading the entire law. They're pages and pages. I'm going to be reading the relevant sections. So you can go and look up the entire law yourself. And I recommend you do that if you have an interest in doing so. I think understanding this as well as you can is always a good thing. So here we go. Introduction and summary of argument. So this begins. There are myriad reasons to deny both plaintiff's motion for leave and to file a bill of complaint and its motion for a preliminary injunction and temporary restraining order, or alternatively, for a stay and an administrative stay. This amicus brief focuses on one. This focuses on one thing, that the Constitution does not make this court, and when they say this court, they are talking about the Supreme Court. This is a brief filed with the Supreme Court. And if you don't know, an amicus brief is a brief that is filed by people who have an interest in the case, but who are not a party to the case. So there was a lot of amicus briefs filed by various people. So you had the actual briefs from Texas, and then you had the filings from the other states that Texas was suing: Wisconsin, Pennsylvania, Michigan, another one I forget offhand. But then, yeah, you had a lot of different amicus briefs filed by a lot of different people. And so this is just one of them. But this one really helps make the case. This makes the best case specifically for why the suit that Texas filed just simply did not have standing, because Texas simply was not a proper party to this suit because they didn't have legal standing. And this will prove that, and we will be, yeah. So anyways, as it says, the Constitution does not make this court the multi-district litigation panel for trials of presidential election disputes. To the contrary, pursuant to the Electors Clause and Title III of the U.S. Code, Section 5, and hang on, I will be pulling those up here too. Hang on a second. So, first we have the Electors Clause, which is right here. That is Article 2, Section 1, Clause 2, that the president shall, together with the vice president, be chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole numbers of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. And then next it was Title III of the U.S. Code, Section 5, and that says, so 3 U.S.C. Section 5, determination of controversy as to an appointment of electors. If any state shall have provided by laws enacted prior to the day fixed for the appointment of the electors for its final determination of any controversy or contest concerning the appointment of all or any of the electors of such state. Hang on one second here, I gotta change something. There we go, now I can read. Alright, sorry about that. So I'm going to start that over. I couldn't read that very well. If any state shall have provided by laws enacted prior to the date fixed for the appointment of the electors for its final determination of any controversy or contest concerning the appointment of all or any of the electors of such state by judicial or other methods or procedures, and such determination shall have been made at least 6 days before the time fixed for the meeting of the electors, such determination made pursuant to such law, so existing on said day and made at least 6 days prior to said time of meeting of the electors shall be conclusive, and shall govern in the counting of the electoral votes as provided in the Constitution and as hereinafter regulated, so far as the ascertainment of the electors appointed by such state is concerned. So back to the amicus brief here. So pursuant to the Electors Clause and to 3 U.S.C. Section 5, state legislatures have made state courts the tribunals for presidential election disputes. This court's only jurisdiction is appellate. And keep in mind, whenever this brief says this court, they're always referring to the Supreme Court. So, the Electors Clause and 3 U.S.C. Section 5 contradict the plaintiff's unprecedented argument that a presidential election dispute is a controversy between two or more states. One way these provisions contradict the plaintiff's argument is by authorizing each state to delegate by statute the adjudication of all controversies or contests concerning federal presidential election results in that state and to that state's courts. Such statutory delegation to state courts is part of each state legislature's chosen statutory manner for presidential elections, as much as are the statutes on, for example, mail-in voting. A state's chosen manner applies exclusively according to McPherson and Blacker. McPherson and Blacker being a case that states the validity of a state law providing for the appointment of electors of president and vice president having been drawn in question before the highest tribunal of a state as repugnant to the laws and Constitution of the United States, and that court having decided in favor of its validity, this court has jurisdiction to review the judgment of the revised statute section 709 under the second clause of Article 2 of the Constitution. The legislatures of the several states have exclusive power to direct the manner in which the electors of presidents and vice presidents shall be appointed. Such appointment may be made by the legislature directly or by popular vote in districts or by general ticket, as may be provided by the legislature. If the terms of the clause left the question of power in doubt, contemporaneous and continuous subsequent practical construction has determined the question as above stated. The second clause of Article 2 of the Constitution was not amended by the 14th or 15th Amendments, and they do not limit the power of appointment to the particular manner pursued at the time of the adoption of these amendments to or secure to every male inhabitant of the state being a citizen of the United States from the right from time of his majority to vote for presidential electors. And keep in mind that this is a case from 1892, so when they say all male citizens, they mean all male citizens because this was before the 19th Amendment, at which point that changed and the ladies got to be involved as well. So, a state's chosen manner applies exclusively, according to McPherson and Blacker, absent some other constitutional constraint. See Chifalo v. Washington. And that's really clear. That merely states that state legislatures may enforce pledges signed by the electors to constrain their vote to the candidate who won that state's electoral vote. So what they are saying there is that the state's chosen manner applies exclusively unless there is another constraint applied by the state. So if a state passes a law that says if you are an elector and you sign a pledge to vote for the candidate who wins the popular vote, we are able to hold you to that. That is all that means. So, anyways, a state's chosen manner applies exclusively, absent some other constitutional constraint. There is no constitutional constraint against state courts being the trial courts for presidential election disputes. Moreover, 3 U.S.C. Section 5 expressly and properly enables a state to designate its state tribunals as the conclusive arbiter of any controversy or contest concerning presidential election results in that state. In the rare instance that a state Supreme Court's ruling violates a federal constitutional provision or statute, this court has appellate jurisdiction. See Bush v. Gore. So this is the primary holding from Bush v. Gore, said that despite violating the 14th Amendment by using the disparate vote counting procedures in different counties, Florida did not need to complete a recount in the 2000 presidential election because it could not be accomplished in a constitutionally valid way within the time limit set by federal law for resolving these controversies. Remember, that's what I said, is there was a controversy or there was a disagreement between the state legislature and the state Supreme Court, and because that was not resolved by the date set by the federal government, which is the safe harbor deadline, as they call it, because it was not resolved by then the Supreme Court had appellate jurisdiction to step in. That's why Bush v. Gore was valid. And now the per curiam in that case, and the per curiam is just a ruling that is given by either the entirety of the court or whatever the holding majority is. So in this case, there was 7 judges consenting, 2 dissenting, and there were several concurring opinion by individual justices who were in the majority, but the per curiam is the ruling that all 7 judges agreed together collectively was the correct ruling. So the per curiam in the case says that 7 justices agreed that a manual statewide recount would violate the Equal Protection Clause of the 14th Amendment, although only 5 agreed on the appropriate remedy. The court emphasized that standards for manual recounts varied arbitrarily across counties and even precincts, so individual voters could not be sure that their participation in the democratic process would be given the proper weight. Florida's rule that a clear indication of the intent of the voter was required to make the vote count seemed too vague to be uniformly applied. However, the court carefully limited its judgment to these specific circumstances. Since the state could not finish the recount within the deadline set by state law, the recount was ended and the case remanded for further proceedings not inconsistent with the opinion. Gore thus had the opportunity to continue pursuing litigation at the state level. So, it goes on to say, plaintiff's motion makes a mockery of federalism and separation of powers. It would violate the most fundamental constitutional principles for this court to serve as the trial court for presidential election disputes. And the first argument made in the case, 1. A presidential election dispute is a controversy within one state, not between 2 or more states. The plaintiff raises the unprecedented assertion, contrary to 230 years of history, that a presidential election dispute is, under 28 U.S.C. Section 1251A, which states, 28 U.S. Code 1251, original jurisdiction, subsection A. The Supreme Court shall have original and exclusive jurisdiction of all controversies between 2 or more states. So what this is saying is that though the plaintiff is claiming original jurisdiction because this is a controversy between 2 or more states, the plaintiff's brief in support for motion of leave to file a bill of complaint on pages 7 and 8 is jiggery pokery, which I love that they use that. And it is contradicted by the Electors Clause and 3 U.S.C. Section 5, the sections we read at the beginning. And they go on to say, the Electors Clause begins, each state shall appoint in such manner as the legislature thereof may direct. This plainly makes the appointment of electors a state-by-state matter. See also U.S. Constitution, Amendment 12, and that is the amendment that just updated the way that the Electoral College functioned. I've actually made a video on that recently. I'll put a link to that video in the description because the 12th Amendment is really kind of contrived and strange to explain. So I have a video that covers that actually really, really well. So if you're curious what the 12th Amendment and that change to the Electoral College means, it really has no direct effect on this case because we all understand functionally how the Electoral College works. This is just a change that was made because the Founding Fathers did not contemplate the existence of political parties, and by the third election, that had made voting for president just a complete fucking disaster. And yeah, so they essentially changed it. Well, I guess I'll go into it real quick here. Why not? So the Constitution under Article 2 initially created it so that what happened with the Electoral College was that there was 2 votes given. Each elector made 2 votes, and the vote who got the most Electoral College votes was the president, and the person who got the second most votes was vice president. And again, they didn't count on political parties. So, for example, in the third election, it was who was it? John Adams, and his running mate, I believe, was Thomas Pinckney from South Carolina, who was supposed to be his vice presidential candidate. But the problem is that while all the electors cast their first vote for John Adams, too many of them withheld their second votes for Thomas Pinckney. And so what happened was the second most votes went to Thomas Jefferson. And so you had 2 men who, though they used to be very, very good friends, were at that point literally enemies, literally hated each other as president and vice president. And that was just a complete clusterfuck. And then in the next election, in the third election, what happened was you had, it was John Adams versus Thomas Jefferson again. But what you had was Thomas Jefferson was running for president, and Aaron Burr was running for the Democratic Republican vice president. But the Democratic Republican electors remembered what happened before with John Adams and Charles Pinckney, and they didn't want that to happen again. So what happened was all of the Democratic Republican electors cast their first vote for Thomas Jefferson, and then all of the Democratic Republican electors cast their second vote for Aaron Burr, and you had a tie. And so, though Aaron Burr was supposed to be vice president, he decided that he wasn't going to gracefully step aside and say, no, Thomas Jefferson was supposed to be president. He saw a chance to be president, and he went for it. It's really interesting case. It ended up going to the House of Representatives, and I think it took some 34 votes in the House of Representatives before, essentially, of all people, Alexander Hamilton, who hated both of those men, but just hated Aaron Burr more, finally stepped in and convinced all the Federalist members of the House that, look, Thomas Jefferson is definitely the lesser of two evils here. So, why don't we just give this to him? Because, going to be a Democratic Republican. If it's going to be, it might as well be the lesser of two evils. Which, yeah, it's just really interesting. It is actually sort of the beginning of the dispute that ended up leading to the duel between Alexander Hamilton and Aaron Burr, and that was really the only service Aaron Burr ever really did for his country was killing Alexander Hamilton. So I guess maybe there were some good benefits to keeping the system as it was. It took care of Alexander Hamilton for us, but I'm getting way off course here. Yeah, sorry. Why don't we get back to the matter at hand? Sorry. Anyways, so yeah, according to Amendment 12, the electors shall meet in their respective states. And that is the opposite of a controversy between two or more states. Each state's power over its state's manner includes its legislature's power to delegate the authority to run the election and to oversee election disputes to a Secretary of State and to its state courts. You can see Bush v. Gore, and cut here. I actually have that pulled up here. This references a different part of the ruling, and this references this was a concurrent opinion given by Rehnquist and joined by Scalia and Thomas. And what they did here is they just generally reiterated the logic of the dissenters in the Florida Supreme Court. Rehnquist pointed out that the federal courts do not usually have the authority to determine whether a state Supreme Court has properly interpreted a state statute, but he felt that the per curiam opinion appropriate refrained from making that judgment. So, in particular, the exclusive manner includes statutorily defined state court proceedings for post-election protests and contests concerning, among other things, canvassing and certification. Likewise, 3 U.S.C. Section 5 states that when any state shall have provided under pre-election law for its final determination of any controversy or contest concerning presidential election results by judicial or other methods or procedures, a state Supreme Court's decision about its state's laws is conclusive. For the electors appointed by such state, the multiple reference to a state-by-state process is confirmed by the drafting history of 3 U.S.C. Section 5, in which sponsors repeatedly stated that the phrase, its final determination by judicial or other methods or procedures, meant determination by the state tribunal. They were very specific and very clear about that the final determination, the final judicial determination, meant determination by a state tribunal, not the Supreme Court. So, let's see here. So this bill provides that where the state has, so this is from the dicta in that case. This bill provides that where the state has created a tribunal for determination of presidential election controversies, the proceedings of that tribunal shall be conclusive. And Senator Morgan said that 3 U.S.C. 5 secures that each state its full electoral power to be expressed and exercised as far as may be under the Constitution through its own laws and through the final and conclusive judgment of its own tribunals. So, in this election, the courts of each of the 4 defendant states have diligently adjudicated each of the presidential election controversies and contests brought before them, including many belated and repetitive cases. And the Bush v. Gore concurrence explained that a state legislature's chosen manner is not merely an isolated section of the code, but rather the general coherence of the legislative scheme. And this gets to, here, I'll pull this up. Here. Uh, and this explains a legal concept that is known as inter alia. And what this says is that you, when you are uh, quoting from a statute about as to the meaning of a law, that you can't pull out a piece of that statute that makes it sound like it's saying something else, that when you read the statute in full, the statute itself is clearly not saying. And you see this a lot of times in Supreme Court cases too. And this actually happens a lot with Supreme Court dicta, where people will take the obiter dictum from the case, and they will pull out a section of that and they will quote that. But what they won't mention is that that isn't actually part of the official holding of the court. That the obiter dictum is just it Latin essentially means by the way, so it means something additional that the courts have said on top of the official ruling. So you'll see that a lot in so Supreme Court cases. It's considered dicta, which is it's extra stuff that was said but wasn't part of the official legal holding, that is often pulled out by people and used to pretend that a law or that a ruling is saying something it is not. And with law, it is what's known as inter alia, which also I think means by the way. Yeah, I think it's Latin for by the way. So yeah, that's what we're talking about here. So, and what it's saying is isolated sections of the code may well admit of more than one interpretation, but the general coherence of the legislative scheme may not be altered by judicial interpretations so as to wholly change the statutorily provided appointment of responsibility among these various bodies. If any election, but a presidential election, the Florida Supreme Court can give as little or as much deference to Florida's executives as it chooses, so far as Article 2 is concerned, and this court will have no cause to question the court's actions. But with respect to a presidential election, the court must be both mindful of the legislature's role under Article 2 in choosing the manner of appointing electors and deferential to those bodies expressly empowered by that legislature to carry out its constitutional mandate. In order to determine whether a state court had infringed upon the legislature's authority, we necessarily must examine the law of the state as it existed prior to the action of the court, though we generally defer to state courts on the interpretation of state law. See Mulaney v. Wilbur. There are, of course, areas in which the Constitution requires a court to undertake an independent, if still deferential, analysis of a state law. So, they say, using Pennsylvania as an example, statutes enacted by its General Assembly both give state courts original jurisdiction over presidential election disputes in that state. See 25 PS 2291. So right here we have 3291, excuse me. So this says the several classes of nominations at primaries and elections of public officials which may be contested in this Commonwealth are hereby distinguished and designated as follows, to wit: Class 2, nominations and elections of electors of President and Vice President of the United States, and all officers of this Commonwealth, including judges of the court, except Governor and Lieutenant Governor, who now or are hereafter shall be required to be nominated or elected by electors of the state at large, and nominations of United States Senators. So, in dispute, see, law we just read, and make the Pennsylvania Supreme Court, not this court, the final adjudicator of state law in all cases, including presidential election disputes arising in Pennsylvania. So neither manner in the Electors Clause, nor its final determination in 3 U.S.C. Section 5 permits any exception, that would allow the courts to override these Pennsylvania statutes or similar statutes in Georgia, Michigan, and Wisconsin. When a text does not include any exceptions to a broad rule, courts apply the broad rule, as said in Bostock v. Clayton County. The delegated final authority of state courts is a part of the exclusive manner directed by a state legislature just as much as are the state's statutes regarding, for example, mail-in voting. Plaintiff has offered no legal argument how the word legislature permits overriding the state statutes that give state courts both original jurisdiction and final authority to interpret state election laws and decide any remedial issues thereunder. This does not mean that under the Electors Clause, every interpretation of state law by a final state Supreme Court decision in a presidential election dispute is immune to review by this court. As Bush v. Gore illustrates and Chiafalo held, this court can exercise discretionary appellate review if state election law or any remedial issue thereunder, as interpreted by a state Supreme Court, violates some other constitutional constraint. This is not remotely the case. And now move on to their second point. The plaintiff's original action violates basic constitutional principles. Federalism and separation of powers protect our liberties. See Shelby v. Holder. Shelby v. Holder. The Voting Rights Act of 1965, under 42 U.S.C. 1973, subsection A, was enacted to address racial discrimination in voting. Section 2 bans any standard practice or procedure that results in a denial or abridgment of the right of any citizen to vote on account of race or color, applies nationwide, and is permanent. Other sections apply to some parts of the country. Section 4 defines covered jurisdictions as states or political subdivisions that maintain tests or devices as prerequisites to voting and had low voter registration or turnout in the 1960s and early 70s. Section 5 provides that no change in voting procedures can take effect in covered jurisdictions until approved by federal authorities through preclearance. The coverage formula and preclearance requirement were to expire after 5 years, but the act was reauthorized. In 2006, the act was again reauthorized for an additional 25 years, but coverage still turned on whether a jurisdiction had a voting test and low registration or turnout almost 50 years ago. Shelby County, in the covered jurisdiction of Alabama, sought a declaratory judgment that sections 4B and 5 are facially unconstitutional. The district court upheld the act, the D.C. court affirmed, and a 5-4 Supreme Court reversed, finding section 4 unconstitutional. Its formula may not be used to require preclearance. States have broad autonomy in structuring their government and pursuing legislative objectives. The 10th Amendment reserves to the states the power to regulate elections. There is a fundamental principle of equal sovereignty among the states. The Voting Rights Act departs from those principles by requiring states to request federal permission to implement laws that would otherwise have the right to enact and execute. The act applies to only 9 states and additional counties. In 1966, the departures were justified by racial discrimination that had infected the electoral process in parts of our country for nearly a century. So, that the coverage formula was rational in practice and theory nearly 50 years later, things have changed dramatically. Voter turnout and registration rates in covered jurisdictions approached parity. Blatantly discriminatory evasions of federal decrees are rare. Minority candidates hold office at unprecedented levels. Congress, if it is to continue to divide the states, must identify jurisdictions to be singled out on a basis that makes sense under current conditions. Data compiled by Congress before reauthorizing the act did not show anything like the pervasive, rampant discrimination found in covered jurisdictions in 1965. Congress reenacted the formula based on 40-year-old facts with no logical relation to the present day. So, federalism and separation of powers protect our liberties, as see Shelby County v. Holder. They divide power among sovereigns and among branches of government precisely so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day. See New York v. United States. New York v. United States. The primary holding. The federal government cannot commandeer a state into enacting a certain law. The facts of the case are such. The Low-Level Radioactive Waste Policy Amendment Act of 1985 resulted from a plan developed by the National Governors Association at the time. Only 3 states had disposal sites for radioactive waste. Under the act, all states were required to join a regional waste compact, create a disposal site in the state, or otherwise find a way to dispose of their own waste, rather than requiring the 3 states to handle all of the nation's radioactive waste. The act required the other states to provide access to active sites within 7 years. The federal government encouraged states to comply with the time window by allowing states to dispose sites to refuse access to states that did not comply, with authorizing them to impose a surcharge on the use of the site, which would be returned to the other states once they complied. Any state that failed to comply within the 7-year period would be forced to take title to all the waste generated within its borders or pay damages to the in-state waste generators. New York failed to either join a regional waste compact or build its own facility. It argued that the 10th Amendment protected its state's sovereignty against compliance with the act, and that states that had developed facilities intervened in the action. The lower court dismissed the case. The majority opinion held was written by Sandra Day O'Connor. The first 2 incentives of the federal plan are appropriate, but the third is not. The federal government may condition funding on compliance or offer states a choice between using the federal plan or having their own laws preempted by federal laws. But they cannot force states to take title to the waste or accept liability for disposing of it. States should not be held responsible for their waste generators, which should be required to shoulder these burdens. Federalism concerns prevent Congress from issuing orders to state officials. Although the Constitution gives that authority to the federal courts, it is not among the enumerated powers of Congress, so this action violates the 10th Amendment. States may not agree to give up their sovereignty, even though this federal law resulted from a compromise among them. So, consistent with these principles, the Constitution and Congress have enabled each state to provide law and to adjudicate in its own courts all controversies about the presidential elections in that state. This court should reject the plaintiff's request to transfer the powers of 50 state court systems to this court. The caution of Rucco v. Common Cause fits here even more, which states, what the plaintiff seeks is an unprecedented expansion of federal judicial power. The expansion of judicial authority would not be into just any area of controversy, but into one of the most intensely partisan aspects of American political life. That intervention would be unlimited in scope and duration. It would recur over and over again around the country with each presidential election. Consideration of the impact of today's ruling on the democratic principles cannot ignore the effect of the unelected and politically unaccountable branches of the federal government assuming such an extraordinary and unprecedented role. The conclusion, this court should deny the plaintiff's motion. So there you have it. I think we have a good understanding of what legal standing is, how it applies, its relationship between citizens and government, why citizens are not states, and why Texas did not have legal standing in this case that it brought. To those of you out there who are very passionate Trump supporters and you're upset that he lost, I'm sorry about that. I will reluctantly admit that I would slightly prefer to have Trump over Joe Biden, not by a whole lot, but by enough. But look, I get it. I really do. So I mean, yeah. Well, maybe not. I mean, I'm a libertarian. I vote every year knowing my candidate is going to lose horribly. So yeah, no. But no, what I mean is that I get it. You know, I get that you really like Trump. You're very, passionately believe that he is something good for the country. And while I may not always agree with you on that point, I respect the reason you feel that way, and I respect your passion for your political cause and your political movement. And so I don't mean to be overly critical here, but it's just the fact is that no matter how much you want your candidate to win, that doesn't mean that the law can be subverted, and especially not the supreme law of the land. The Constitution is absolutely crystal clear on this. I mean, this is an issue that it violates separation of powers, it violates basic federalism, and it violates legal standing, which, as I've explained, exists under the Constitution via the Electors Clause of Article 2 and by Section 3, Title 3 of the U.S. Code, Section 5, as we have gone over here. So it's simply, I don't know. Look, I get it. There was a lot of very suspicious shit that went on election night. Maybe there was fraud. Maybe there was widespread fraud. Maybe there was enough fraud to change the election. I don't know. I don't know. Maybe there was. Maybe there wasn't. I don't know. But it just, yeah, your disappointment with this doesn't change the fact that what you are asking for is entirely unconstitutional, and I would respectfully suggest that you consider this an opportunity to return to true constitutional conservatism, which is a belief in the limited jurisdiction of the federal government and of the general jurisdiction of the states. And that when you ask, where do the American people have standing? The answer is very clear. You have standing in your state legislatures and your state courts. Now, you don't have standing in the Supreme Court. Texas didn't have standing in the Supreme Court, not in this case at least. So it just, yeah, I would ask you to take that into consideration. I understand why you guys are upset about this, and I disagree with you, but I respect where you're coming from. But you're wrong. You're wrong. You're wrong. I'm sorry. You're wrong. And I hope that maybe this appeal to you will help you to see that being angry about something and having suspicions that something took place is not the same thing as, the Supreme Court, like fucking you in the ass. It's not. That's not what they did. And in fact, if you remember what I said earlier, when I said that legal standing in part came from the cases and controversy clause in Article 3, that legal standing is not a limit on the citizens of the United States. It's not a limitation on the people. It is a limitation on the federal government. That should be a good thing. You're constitutional conservatives. You should want constitutional constraints on the federal government to be upheld. This isn't the people getting screwed over. This is you asking the federal government to regulate itself in a way that is patently unconstitutional. So yeah, I'm a libertarian, but I consider myself a constitutional conservative too. And yeah, I hope that you guys will understand that this, while I'm not a Trump supporter, I'm not a Republican, I am a constitutional conservative, and I'm with you guys on that. And I hope you guys will see this as a plea from one constitutional conservative to another to say that, if you truly are a constitutional conservative, just hear this message, and if you doubt the information I just gave you, go look it up. I will have links to the brief that I just read from. I'll have links to all the cases that I quoted from. I'll have links to all the laws I quoted from. Go do the research for yourself. I don't like to make appeals from authority. I'm not saying, believe me, because I'm a constitutional lawyer and I know more than you. But what I'm saying is that I'm giving you. You don't have to trust me when I say this, but I am giving you all the information you need to confirm that it is true. And even if you doubt me and don't take me at my word, and I don't expect you to take me at my word, I would ask that before you write me off, just do your own research into this information I've given you and ask yourself honestly, if your argument still holds up. So anyways, yeah, I've been droning on here long enough. So, look, if you like the show, I would ask you to take a moment and subscribe to the channel. I cover a lot of stuff. Like I said, this is really a very different kind of show for me. I don't usually go this off the cuff. I usually do informational and educational stuff about constitutional history, past Supreme Court cases. I'm working on a great series right now. I put out part 1 on a history of the Bill of Rights. I've got part 2 coming soon. I've actually had that done now for a while. I've just gotten so caught up with these videos that it's been delayed. But I've got a lot of great content that, even if you're a Republican, constitutional conservative, Trump supporter, even if you don't like what I had to say in this particular video, I think I have a lot of other content that you'll really, really like. So maybe consider subscribing to the channel anyway, even if you didn't like what I had to say here and you don't agree with me, which is fine. And if you like the video, take a second, hit the like button. If you disliked it, hit the dislike button. And feel free to leave me a comment in the comment section below. As you can tell, I will welcome all comments. Love, hate, agreement, disagreement, anger, joy, ecstasy, blind adulation, whatever you have, I will take it. So, leave me a comment. Let me know what you thought about this video. I would genuinely be interested to hear your thoughts on this. And then what I would ask is if you like this video, if you would just take a minute and think of 2 people who you think would also like this video, who would like to hear this information or be interested in this, and just take a moment and send this show to them. And if you would just share the show with 2 people and you would help me grow the channel that way, I would be very, very grateful for that. And so if you hated the show, you can always go ahead and think of two people you know who you think would also hate the show, and just take a moment and share it with them because the fact is I'm a masochist, and to be honest, your hate, it gets me off. So, anyways, yeah, again, this has been Categorical Imperatives, talking about legal standing. I have been Lockean Liberal, and yeah, until next time, take care, and as always, Delenda as Carthago.